Christmas! Is it actually a crime to fart on someone?
And I'm out.
People have asked.
No one's asked.
So the most likely criminal offense here would be battery. And I actually found one case where someone was charged with battery for farting on someone. Enter Jose Cruz, a steel worker from West Virginia, who was pulled over at night for driving with no headlights. He ended up failing 3 sobriety tests and was taken to be breathalyzed and booked at the police station, where, according to court documents, he passed gas and fanned it with his hand at the police officer who arrested him, stating, "Here, put that in your breathalyzer," to demonstrate. No? The court documents go on to explain that the gas was very odorous and created contact of an insulting and provoking nature. Cruz, for his part, admitted to weaponizing his fart. But okay, how is this actually a crime? Well, battery simply involves intentionally making harmful or offensive contact with someone else. That's really it. It's a super broad crime. And in this famous case, the court held that intentionally blowing cigar smoke at someone's face can constitute battery. So it stands to reason that blowing butt smoke could also count. All that said, while Cruz was charged with battery, prosecutors ended up dropping the charge while still pursuing that DUI. Has been declared ineligible to run for president. At least that's what headlines like these are saying, but that's actually pretty misleading.
And why did you lead with that? Anyway, here's what actually happened. Back in September, this lawsuit was filed with the Colorado State Court. The point was to have Trump deemed ineligible to have his name on the Colorado ballot in the 2024 election because, according to the lawsuit, he violated Section 3 of the 14th Amendment, also known as the Disqualification Clause.
Which, put very simply, says you can't run for president or any other office if you've engaged in an insurrection. The lawsuit spends over 100 pages making the case that Trump did commit an insurrection, including numerous tweets, news articles, and photos. The lawsuit made its way up to the Colorado Supreme Court, who agreed. They held that Trump is constitutionally ineligible to run, and so he cannot appear on the Colorado ballot.
Okay, tons of things. First, this ruling only applies to the Colorado ballot and the 10 electoral votes to be won there, although other state courts could theoretically do this.
Second, this is completely unprecedented. A former president has never been removed from a presidential ballot. There are a lot of critics of this ruling, and the term civil war is now trending on X.
Critics say that Trump has never been convicted of an insurrection, nor was he ever impeached for it, and that the court, which is comprised of all Democrat justices, is politically weaponizing the law. Whereas supporters of the decision say that the Disqualification Clause doesn't actually require any convictions or impeachment, just a determination that an insurrection was committed, which the court found based on the evidence.
The last thing to note here, and perhaps the most important, is that this ruling from Colorado is absolutely going to be appealed up to the U.S. Supreme Court. They'll have the final say, and it's very likely they'll overturn this ruling and void the whole thing.
From Chicago is suing a bunch of people over posts made about him in the Are We Dating the Same Guy Facebook group, and it has stirred up so much controversy.
It all started with a viral sensation of West Elm Caleb back in 2022, where tons of women made viral posts about how they'd all been allegedly dating the same guy. Following this, tons of Are We Dating the Same Guy Facebook groups popped up, and now exist for almost every major city and include 4 million users.
Members tout it as a helpful place to learn about men in their area, to see if they're actually dating other people, if they have any red flags, or even histories of abuse. But critics say that the groups invade men's privacy. privacy, and that they can cause serious harm because the allegations aren't vetted.
Which is precisely what this man has claimed in his lawsuit. He says that his photos and name are posted all over the group, with numerous women saying that he's clingy or obsessive, referring to him as a psycho, and even posting screenshots of their texts together. You can form your own opinions here, but the law is actually way more complex than you might think.
We've seen a lot of people talk about how truth or opinion are defenses to defamation, meaning if what users say is true or is just their opinion, then they're safe from this lawsuit.
That is true, but this case isn't just about defamation. The man also invokes a brand new anti-doxing law in Illinois, which makes it illegal to post someone's personal information without their consent if the intent of the post is to cause harm. And as a result, the person might experience death, bodily harm, or stalking. And the person does in fact suffer some kind of life disruption.
This is a pretty vague law, and it makes no exceptions for true statements or opinions. So the man's case could arguably apply.
But even if it did, it might not matter, because some have argued that this new Illinois law unconstitutionally restricts free speech. The First Amendment does generally allow you to put someone on blast online, even if your intent is to cause them harm, as long as the stuff you're blasting is actually true.
For example, think about reporters who broke the story on Epstein. The main issue here may not be whether this man wins the case, but whether that law is constitutional in the first place. Woman threw her burrito bowl at a Chipotle worker and was charged with 1 count of assault.
Yes, throwing something in a person's face is assault.
At court, the woman tried to defend her actions by telling the judge that her burrito bowl looked disgusting, to which the judge responded, "I bet you aren't going to be happy about the food you get in jail."
The woman ultimately pleaded guilty, and the judge sentenced her to 180 days in jail. But then the judge got creative. He offered her only 30 days in jail if she was willing to spend the remainder of her 180-day sentence working at a fast food restaurant, and the woman agreed.
So this is a creative idea, but is it actually legal for the judge to do this? Generally, yes. In most situations, judges have super broad discretion to determine what punishment someone actually faces.
Typically this comes in the form of prison time or fines, but judges can step outside of the box if they want. One judge in Ohio is particularly renowned for his creative sentences, including sentencing someone convicted of criminal mischief at a county fair to shovel animal poop from that fair, and sentencing someone convicted of vandalism to paint the courthouse with a toothbrush.
Importantly, these creative sentences are usually presented as a choice, as in you can go to jail or you can do this other thing. This helps avoid the argument that these are cruel and unusual punishments, which would be a violation of the 8th Amendment.
Overall, some people really like these creative sentences, finding them more meaningful and a good way to reduce overcrowded jails.
But others prefer that judges stick to traditional punishments instead of experiments. For example, some might ask, who's actually going to hire this woman?
And isn't it kind of a total diss to actual fast food workers to use their real everyday job as an alternative to jail?